What are you on there, 4?
I am. Thank you, Chairman. Thank you, Senator Dickerson, for being here. And we'll go ahead and pray for everybody else that's not here yet. Heavenly Father, thank you for this glorious day. Thank you for this world that you've created. Thank you for the members of this committee and for everyone here in attendance to learn more about rivers that you have created long before we were here, and will be here long after we're gone. God, please just keep us ever mindful of the beautiful state that you have created for us, the land, the sky, everything that grows on it and flows through it. In Jesus' name, amen.
Amen. All right, welcome to the Senate Transportation Committee. As we get started here, want to recognize the newest member of the committee and my neighbor in Cherokee County, Mr. Jason Dickerson, who has a significant, actually, work history moving freight all over the country. Senator, would love just to welcome you to the committee and then give you a minute, if you don't mind, if you want to introduce yourself to committee members and people that are here. Yeah. Tell us a little about yourself and why you're excited to be on the most requested committee in the Georgia State Senate.
Thank you, Mr. Chairman. Good morning, everyone. My name's Jason T. Dickerson. I'm proudly represent Georgia's 21st Senate District. That's part of Cherokee County and the north part of Fulton County, Milton, Alpharetta, and Avalon. For me, I'm a lifelong resident of Cherokee County, and some of you may or may not know, but one of the first companies I started when I was 15 years old was a transportation company. I've got 32 years in transportation experience, deal with the EPA, 32 different environmental agencies and governmental agencies across the United States. So I've got a wide range of background from warehousing to transportation, both in on asset base for trucks, airplanes as well, aircraft, and trains. And so just always I'm extremely grateful for Chairman Dolezal to allow me to be on this committee and to see what we can do here for the great state of Georgia. So thank you so much, Mr. Chairman. I appreciate it.
Absolutely. We are glad you're here. This committee over the last couple of years, along with the House, has done a significant amount of work envisioning, planning for, setting up, and then ultimately last year funding our freight and logistics program in the state of Georgia. And we recognize through the work done by GDOT and some other consultants the need to fund a freight network in Georgia. We put that in place with legislation 2 sessions ago, funded it last year, and your expertise in that area will be a welcome one to this committee. So thank you for being here today.
Thank you. I appreciate it.
Before we get started with our 26-line bill that we're going to consider today, just a little bill, I want to also recognize Pro Tem Walker from the great middle Georgia city of Perry. And, I'm not sure if you guys have this issue down there or not, but Senator Dickerson and I certainly do, and Senator Still as well. Do you know what OCGA 40-6-71 says?
No, sir.
Well, it says that the driver of a vehicle intending to turn the left within an intersection or an alley, private road, or driveway shall yield the right-of-way to any vehicle approaching from the opposite direction. And Mr. Pro Tem, you wouldn't believe it. So what the law plainly says is that left turns yield to oncoming traffic, including a right turn. Well, all over the northwest suburbs, ground zero for this is Forsyth County. There are yield signs at almost every intersection telling people turning right to yield to people turning left, in direct conflict with the plain reading and language of the law. And I have lobbied my friends heavily at GDOT. And continue to lobby my friends to provide some guidance here, because it creates tremendous confusion. If you could imagine turning left and wanting to follow the law, so you're yielding to a right turn person, but meanwhile the right turn person is yielding to you because it's a sign that you can't see because it's facing them is telling them to yield, and it turns into what I colloquially refer to as the Forsyth County dance, where the right person yields, the left person yields, both people sit there, and it creates tremendous confusion. Senator Still, have you noticed this just dramatic proliferation of right turn yield signs in our area?
I have, Chairman, but I think to the point, and for the good of the committee, It should be noted on record that Chairman Dolezal has never made a left turn in his life. He always turns right.
This is very true. Well, we're going to open every committee this year with citing that and having discussion about the ridiculous nature of these right turn yield signs that were just invented by some county engineers and have now become the standard. It's not even at intersections necessarily, like stop sign or red light intersections. You can want to turn right into your neighborhood and have to yield to somebody turning left off of just a 2-lane road. It's crazy. Pro Tem, do you have any insight on what we could do to fix this problem?
That sounds incredibly frustrating, and I'm not surprised that you all in the northern suburbs operate that way. We don't where I live, but I will say it's I think, you know, the solution would have been a class action lawsuit, but we passed tort reform, and so that's off the table.
Fair enough. I think we're losing our trial lawyers in the caucus, so I understand we got one incoming as well. So we do want to talk about an important piece of legislation that, although it is only 26 lines, it does deserve our serious consideration. And so we're going to do a hearing on this today. Senator Still, you're welcome to present the bill from there, or there, whichever. What is up there?
Some books.
Okay, that's going to be for you.
Yeah.
Okay, fantastic. Would you like to present
gonna read 'em all.
present the bill from there?
If I could present from here,
Sure.
because a lot of folks are going to be coming up to speak to it
Great.
after. Great. Chairman, thank you. Committee, members of the audience, thank you all for being here. Thanks for getting up for this really important bill. This is Georgia River Heritage. That's what this is about. And I have a particular interest in this, not for the state of Georgia, but just holistically and globally. I have spent the majority of my life involved with and owning a whitewater rafting and kayak construction outfitter. I'll get that, Frank. It's okay. So we operate not in Georgia, so I have no vested interest in this personally, other than just personal. And what I can say to you is this: we operate in North Carolina, Tennessee, Ecuador, Costa Rica, all over the world with our paddling. And so I understand intimately the rite of passage. I understand why it is important for recreational boaters to understand the ability to take their family, themselves, a guided trip on a navigable river, stream, creek, whatever it may be. And so if you look at the information sheet that each of you have, there's a one-page flyer called Freedom to Float, Protecting Georgia's Outdoor Recreation Economy. If you look at the back of it, I think this is what you'll find most interesting. The third paragraph, going back to the 1863 definition of navigable and what that means, and why we need to really protect this rite of passage. We need to enshrine this in law. Now, I will tell you, this bill was written broadly for the purposes of this committee so that it covers all rivers and streams. We acknowledge that there are streams, and I'll just mention one in particular, the Sequoia in Habersham County, where people make a living. Just that section of that stream is used exclusively for trout fishing. We recognize that that's not considered a navigable body of water, but there are, and you'll hear testimony today from one person in particular who's going to tell the story about paddling the Upper Chattahoochee on a guided trip with an outfitter, with his family, who was harassed significantly for being in a very well-recognized body of water in doing that. And so recreational boating is an inherent right of all Georgians, Americans. Georgia has some quirky laws about that, defining property lines and where someone can and cannot go. We know that there are friends that are going to testify today that are in opposition to this bill. And their perspective is valid. They're going to be talking about property rights. They're going to talk about, using water streams for agriculture, for crops, for for cattle. And those are very, very valid. And I think that we need to listen to all of that. And that's why I asked Chairman Dolezal for a hearing on this so that we could begin this conversation and really explore the depth of what it involves and all the different moving parts of who it affects. And with that, I'm happy to answer questions. But we do have several folks that wish to testify to the committee this morning that have come a long way to give us their perspective. And I think that their testimony will certainly give the committee more to ponder and more understanding of what we have here. So,
Can you walk us through what Georgia law is today and what this bill specifically would change about Georgia law?
so what this, if you'll just refer to the bill, right, and we look at where we have, look at line 9, right? Like, so we're looking at relating to water rights, amended exclusive possession by owner of non-navigable streams and interference. We're adding lines 13, so that the General Assembly, that we have no power to compel or interfere with an owner's lawful use of a non-navigable stream for the benefit of those. And there's confusion on that, Chairman, because property lines sometimes cross both sides of a river. Sometimes they go to the bank. Sometimes they go to the center of a river. And if you think about a river as it flows, let's just use for simple explanation, north to south, that line moves. And so as a river flows through a piece of private property, through a city, through a county, as it goes all the way through the state, those lines move. And so, unfortunately, through the study committee that the House did last year, it actually brought more questions than answers about that. And so this just tries to bring some clarification to it, because it does have a lot of ambiguity over where those property lines are.
Great. So functionally, currently, if there's a property line that's in the middle of a stream, I can't ride a kayak down that stream.
That would be the argument of that property owner, yes.
And you are codifying into law here that I would be able to traverse the stream solely for passage.
Solely for passage, not to get out of your boat, not to hunt, not to fish, not to do anything to disturb the land on the banks. Correct.
Okay. All right. Any questions for Chairman Still before we get to folks who want to speak on this? All right.
Mr. Chairman.
Yes, Chairman Burns on 3.
Just a point of clarification. If a property owner owned both sides of the stream, had property on both sides of the stream, your bill would still allow right of passage through that stream in the stream flow or the river flow. Is that correct?
If they were able to originate upstream of that,
So if they
flow
did not
through it-
put their boat in on that private property's land, they put it in at a public access point or at a
Site.
a lawful site, then they could passage, even though the property owner owned both sides of the stream?
Correct. They just, because they don't own the water, right? That's the point, is that the water is flowing through the property, but it's not stagnant. It's not a pond or a lake sitting stagnant on that land. It's flowing through it. And as long as there's a place for them to be able to exit in some public access way or with permission from an owner, then they should be able to do so.
Or an outfitter might have a landing or whatever. And again, I've kayaked down the Etowah. I am concerned about your comment. I'm not allowed to fish on the stream?
If it's marked as private land, if someone is stocking that trout stream or some section of it and they're saying, yeah, this is private and we're stocking this for commercial purposes, that someone's not going to float through, fish out their crop and take it with them.
Okay, but if I could, Mr. Chairman, follow up. If I don't own both sides of the stream and I'm float fishing down the stream, could I have access? It might be difficult for him to contain the fish within his property boundary.
Correct. If it's natural fish, natural flow, it's not being stocked and maintained. And I use the example of the Sequoia. So on that river, it's very shallow.
Yep.
I've fished it.
Waded it.
You wade it, about knee-deep water.
Yep.
Those are trophy trout.
Yep.
That are fed and maintained, and they're stationary in that one area. They don't
Sure.
leave.
Yep.
That's where they live.
That's right.
That's their home.
Okay.
So that's the type that we're talking about.
I would like that clarified, please. Thank you.
Yes, sir.
Thank you, Mr. Chairman.
All right, so we are going to give, Senator Gann on 5.
Yes. Thank you, Mr. Chairman. Said to my esteemed colleague, I'll ask you, do you have any idea what the rules or regulations are on flying an airplane over your home? If somebody wants to fly an airplane over your home, because we're talking about land, water, and air. If somebody wants to fly an airplane over your home, is there any restrictions that you know about on that?
Well, the FAA has restrictions on the elevation that you can fly it, yes.
And you know what that is?
I don't, since I'm not a pilot.
I believe, and maybe we've got a more learned crew here, but I believe it's 500 feet. You got to maintain 500 feet above somebody's property, so you're not interfering with their opportunity. I'm curious. I said, okay, when you have a stream, said because it depends on whether it's raining or not, whether sometimes you have these streams or not. Said when you say public access, would that be where a roadway crosses the stream? If there's a culvert at a county or city or state roadway, would that be a public access point?
Some roads do have launches, some don't. So it depends on if you've got a safe place to be able to launch and a safe place to exit. You can't launch and exit from someone's private property without their permission, though.
Well, but I've actually worked to build a launch on a state highway at the Madison-Elbert County line on the Broad River. To create a public access point.
Right.
But one of the things that for me, and I understand what you're trying to do, but I think that this would be a grave taking of property for private landowners all over the state. And that's where, to me, I'm looking for some way that most of the river owners that I talk to, where they own the bed of the stream, they own the stream, and the property is their kayakers that are going across their stream. Most of them have not ever told me that, or none of them have ever told me they want to stop kayakers from going down something like the Broad River in my district.
The Broad's a pretty significantly traveled river, though.
But that's where, to me, I can see, I have creeks and streams on my property, and I don't want to give somebody access to my property just because what you're doing here. I'm like, it's just like I don't want to give somebody flying an airplane right over my house. And I'm just trying to figure out what motivated the bill.
I think you'll hear about that through testimony, through people's stories about where the line has definitely been blurred between people launching for recreational boating on the Broad River or maybe the Upper Chattahoochee, and then all of a sudden someone felt that their property rights were being infringed and then tried to stop them from doing so on a commercially accessible river.
And that's a good transition point to getting to some of this testimony. We'll come back and have discussion and questions afterwards. I'm going to ask, just because we have a number of meetings that we're pressing up against at this point, I'm going to ask speakers to keep your comments to 3 minutes. Please try to give us new information. I'm not going to buzz you off, but just please don't go on for 15 minutes and make me call the next person up. We're going to start with Jennings Hughes. Speakers can step up to the podium there. I'll keep the podium mic on. Just introduce us. Tell us who you are if you're here on behalf of anyone. Certainly if you're a lobbyist, please let us know that, and then tell us your thoughts on the bill.
Thank you, Chairman. Thank you, Senators. I'm Jennings Hughes. I am a lobbyist. I lobby on behalf of the Georgia Association of Convention and Visitors Bureaus. Tourism is our big issue. This is just a piece of tourism. People come to Georgia, they float, they fish, they boat. We just kind of want to have y'all consider the economic impact of those industries. There are going to be a lot of experts today who, they operate a kayak operation. They help people fish for lovely trout. I appreciate it's a difficult conversation y'all are having. We just want y'all to consider tourism, and would like to hear from Rena and Joe and the people at Georgia Rivers later. And thank you, Senator Still, for carrying the bill. if y'all have any questions about tourism, I'm always here to help, so.
Thank you, Mr. Hughes. And Rena, he set you up. You're up next.
Thank you, Senator. My name is Rena Peck. I'm Executive Director of Georgia Rivers. We run the Water Trails program for the state. Joe Cook is head of Paddle Georgia, and we'll speak with y'all later and can answer some of those legal questions along with some others. The way I explain it is hunting and fishing are tied to the land. Floating is not. It's an easement. Just like you've got private landowners along St. Simon's Beach, that beach is a public easement for people to walk up and down, and so are our rivers, based on common law from the beginning of Georgia, America 250 years ago. I would like to read just a quick statement from Clay Courts. He is one of the ownership group of Nantahala Outdoor Center. They employ 600 people, and wanted me to read this to y'all. Clay Courts. As the owner of NOC, our business model depends upon boating passage down small rivers like the Cartacay, Chattahoochee, and Chattooga. Each of these streams would likely fall under the category of non-navigable based on some interpretations of Georgia's current definition of navigable. This bill provides certainty for our operations by affirming the right to pass down small, non-navigable streams. Non-navigable doesn't mean they're not floatable. So you can float down non-navigable streams just like navigable streams. That was my 2 cents. Back to Clay. So it also promotes outdoor recreation tourism and related jobs in Georgia while putting Georgia on a level playing field with neighboring states where such policies are already in place: North Carolina, South Carolina, Tennessee, Florida. Clay Courts, I urge you to vote yes on Senate Bill 511 and to protect these jobs and enable us to grow our business in Georgia. Thank you.
Yeah, I've actually got a question for you, Ms. Peck, as well. So your contention is essentially that up until some point in time in Georgia, common law provided for passage on these non-navigable streams. Somebody wrote, somebody wrote the current language into law, and that has essentially, in your view, changed what has been common law, or at least precedent in Georgia. Up until when? When did that change happen?
It depends when, and I'm not the attorney,
Okay.
but it's our interpretation that based on common law, if you can float it, you can boat it.
So, I think the pro tem's got a question for you.
Okay.
I've known him for 8 years, never seen anybody trigger him that way. That was interesting. I think he might disagree with you. So as it relates to the Nantahala gentleman that you mentioned, obviously he has
Yes.
a functioning business. He's operating, sending tubes or rafts or whatever he's sending down these streams. His
Right.
contention is he has fear that under this law that somebody could make a claim that they should not be able to do that.
Right.
Is that
One
correct?
landowner on non-navigable stream, if they think that they've got the law on their side, could say, hey, you can't pass by here, and that could shut down Nantahala Outdoor Center, which is a big employer in our state.
But not knowing when this law came into place, he's been operating, I'm assuming, for decades under the current law without any sort of issue. So
That's right.
help me understand what the actual issue is, as opposed to some fear that something could happen. What's not happening today that you all are trying to solve for?
What's not happening today is some groups, paddling groups from Florida, for example, are scared to come into Georgia for fear they might be arrested. So there are other examples of where paddlers have been asked not to come through. And so that's what's happening, is
Do you
that
know
we're
of any-
shrinking our use of our water trails, which brings such wonderful rural economic development.
So some landowner comes out and yells at somebody who's floating down the river and says, hey, I own the river, go away. But that may still happen even if this law passes. I'm thinking about, so have there been arrests that you know of under this law?
I think there have, yes. And we have one person here from Native Fish Coalition who's run into this issue as well.
Okay. I think Pro Tem Walker.
So I'm certainly, hey, Rena.
Hey,
I'm certainly no expert in this issue, but I know it's been debated and discussed ad nauseum for a number of years. I thought we had sort of resolved this. I think it was maybe in the 24 session, but clearly not. My understanding is that in nowhere in Georgia, statutory or common law, has there been public ownership of waters or land under non-navigable streams. Georgia law allows the property owner to own the bed of the creek if it's non-navigable, and that's often the case, where you have two property owners on either side that own it to the center.
right.
I mean, this is clearly a major shift in public policy and is a taking of private property. I can't fathom that we would do this.
So that's the second.
I'm glad to respond.
Yeah, I'd love to hear, because
Okay.
that's the second
And
reference to this.
fathom
concept.
was not, I didn't mean, that's no pun there, but.
Yes. No, the right to float is there. There have been a misinterpretation by some that you're not allowed to float down any Georgia stream, whether it's deemed navigable or non-navigable.
Then why, if that's the case, why have we tried to parse the definition of navigable and non-navigable for decades
Yes.
if that wasn't the key point?
The
I
key-
mean,
yeah, the key
if it-
point-
If your contention is you have the right to float and you always have, then why have we been having this debate for so long, really? I don't think you're correct in that, but.
Well, the debate on navigable, non-navigable has to do with hunting and fishing,
Well,
not floating.
I just don't agree, but.
That's, okay. But Larry, I would love for my lawyer friends to answer that better than I did, so I'm sure they will.
You've got one more question, then we'll get to the lawyers.
Okay.
Senator again.
Brenda, good to have you here.
Thank you.
You know, one of the things that for me, I want to make sure you understand, I get it, there's a lot of business out there that does a lot of things. But, you know, I have to look at private property rights and what's going on. Those businesses, their model is to go across other people's property. And so when I look at, okay, let's fast forward, you've got a creek going across your property and they want to float down your creek. And you decide, well, you know, I own a gazillion acres here and I've decided I want to build a nice lake. So I build a 500-acre lake, you know. Somebody's navigating down the creek that's feeding into your lake. Now do they get to float all over your lake? It's not your lake, it's their lake because it's got a stream coming into it.
I would say no.
What's the,
I would say no, because there's probably a dam there, and so they'd have to get out on the ground, and that would be trespassing.
but they got to your lake via a quote, non-navigable stream. Hey, I'm just asking, you know, did that property just become public access? Because to me, their business model of floating down somebody else's property is only at the behest of those people that own that property. And to me, you know, there's nothing that would prevent those outdoor sports from saying, hey, let's work an agreement with those property owners to do this. To me, the problem is the disrespect that happens with, and I know you promote good boaters and good kayakers and things there. But we have a lot of people that float down these streams that are very disruptive to the property owners. And that's the complaint that I get. And that's the why, when I look at this, I'm like, okay, I want to try to make sure that we do work together to find some type of solution, but allowing in state law trespass on somebody's property, I won't do it.
No, I don't want to do any trespass either.
All right.
But floating through a property is not trespassing.
Thank you, Rena.
Thank you.
That helped, I think, frame the conversation pretty
Okay, great.
well. Craig Pendergast, your handwriting's about as bad as mine. So I apologize if I missed your name. But this says you are an attorney, is that correct?
That is true, Hank. And thank you, Senator Still, for offering this along with your bipartisan co-sponsors.
Can you tell us who you are, if you're here with anyone?
Yes. So I am supportive of the Georgia Rivers position. I am an attorney, lifelong Georgian, graduated from Georgia Law School in 1984. I do real estate law, and water law are particular specialties. I'm actually the person Senator Still referred to who had an experience earlier in my life with my wife and two friends where we were had been shuttled by an outfitter that still operates on the Upper Chattahoochee south of Helen, and we were canoeing on the section by Smith Island. That's a very well-known, nice small rapid. And a gentleman was on the left side, started yelling at us. He had a gun on a stump next to the river, and he said, "Stop, go back. You can't come down here. This is my river." And he waded out into the river, grabbed our canoes, and wouldn't let us go down. He said, "I've called the sheriff." I said, "Okay." And we were very respectful, and I knew to stay in the river. And the sheriff came out, and he said, "This guy's been doing that a good amount. And I don't know what the deal is, but maybe you could," and this guy owned to the island in the middle, and the passable part of the river was on the left side, his side. And the sheriff said, "Well, why don't you just go walk across the island and go down the other side," which was non-paddleable, non-passageable. We went down, and then 3 months later, I got a call from the Fulton County Sheriff saying that a warrant had been sworn out for my arrest for criminal trespass out of Habersham County for that. And I had to deal with that.
You said the river was which river?
This was the Upper Chattahoochee River.
Which is, what classification does that have?
In terms of, it's Class 1 to Class 3. Smith Island is, it's very, very, very paddleable. There's no question.
I guess I'm trying to, would it be captured under this bill, or is it
Oh, yes.
so it's classified as non-navigable as...
Yeah, if the rule of what's, there are multiple definitions of navigability, which adds to this confusion and multiple implications. You've got federal definition of navigability, and then you've got state definition of navigability, and then the common law said there were 3 types of streams, and this was in an 1849 Georgia Supreme Court decision, Young v. Harrison. It said there are 3 kinds of streams. There are navigable streams, which are limited to the arms of the sea, tidal waters. So basically, any freshwater river was deemed non-navigable, even though it could carry boat traffic. And it said, and then there are 2 types of non-navigable streams. And the bed ownership of non-navigable streams was privately owned. But that of those 2 non-navigable stream types, one was ones that are capable of supporting boat passage. And the Supreme Court said those rivers are subject to an easement of passage, a common law easement of passage. And everybody, property owner, understands, or should understand, yet, hey, I have exclusive possession of my property, but if it's subject to an easement, then I've got to allow the easement use. The user of the easement can't interfere with the rest of my property, but there's an easement. And that's what the common law is. Now, the 3rd type of stream was a non-navigable stream that wouldn't support boat passage. And the Supreme Court said those streams are absolutely private. And so we're not talking about a situation of saying, oh, you can wade down my stream, this little stream that comes through a culvert. We're not really talking about rivers that are coming through, anything that's coming through a culvert. We're talking about things that would have a bridge upstream, big enough to need a bridge. And so that's the difference. So and the catch is that the way the statute defining what a navigable stream is now, which was an expansion in 1863, frankly, of bed ownership rights for public purposes. Because what matters about the bed ownership is, among other things, mining sand and gravel, and having your cattle go into it, having fishing rights attached to bed ownership. But none of that deals with passage rights, because these are nature's highways. And since the beginning of the state, canoes have passed through these. But so I wasn't the only person who's had this sort of issue. There was a lawsuit in the 70s where a developer, I think it was Riverbend Apartments up on the Chattahoochee in Atlanta, said people can't go down the river next to my land because I own to the middle of the Chattahoochee River here in Atlanta, where Nantahala Outdoor Center runs operations, and they got a court to agree with them. Said, well, if it can't support deep draft boats, and nothing in Georgia north of the fall line can support deep draft boats, nothing in middle Georgia. Only thing that can support the deep draft barges is going to be down way south on huge rivers. And so, but then another case come along on the Dog River. This goes to a little bit of a question about the owning the lake, where Douglas County built a reservoir on the Dog River, and they didn't want anybody coming into their reservoir. And a suit had to be brought on behalf of an outfitter that was doing kayak training on the Dog River, and it was brought in federal court, and the federal judge said that is federally navigable because it's being used for a commercial purpose. It's capable of being used for a commercial purpose. But then you get other cases that go left and right. So what I'd say this law does is it is not a change in the law. It is a clarification, a confirmation of the common law easement that the Supreme Court recognized in 1849, and then recognized again in 1910 on the Chattahoochee near Columbus, after the 1863 bill was passed. But again, when you get different judges and different sheriffs and different landowners, and all they look at is this statute that says a navigable stream is one capable of supporting boats loaded with freight in the ordinary course of business, and they think, well, freight, that's a barge, so the only thing that's going to be a navigable stream is a deep draft barge, then that sets the tone for this confusion. And so if you pass this clarifying legislation, it's not changing what's the definition of a navigable stream for state law purposes. It is simply clarifying the longstanding existence of that easement. And this has implications on the Broad River in Athens where there are outfitters. It has implications on the Chattahoochee in Atlanta, the Chattahoochee in Columbus, the Etowah, the Broad, all these places have outfitters. And
Any questions from the committee? All right, I think his name is Craig Pender. Is it Grast?
Pendergrast, yes, sir.
G-R-A-S-T, yes. Great, thank you. All right, next up is Joe Cook.
Thank you, Chairman. I'm Joe Cook. I'm with Georgia Rivers. I'll make this brief. I know y'all have things to do. I'm the author of these guidebooks up here, and I lead Georgia Rivers paddle trips. Craig did an excellent job of framing kind of the legal background of it. I want to emphasize again what he said, and that is this is not changing the definition of navigable. It's only about passage. You wouldn't be taking any property from any property owners if you pass this bill, because you're still going to own the stream bed. This is all about a passage or public easement for passage down these streams. One thing I would like to add is, if you look at the history of the General Assembly and the laws that the General Assembly has passed regarding rivers throughout history, the General Assembly has always acted to protect what was most important to the state's economy and to commerce in regards to rivers. And if you look at legislation that was passed in the 1800s, there was actually legislation passed to clarify the Broad River as navigable from the mouth of the Hudson River to the Savannah River. That is the section of the Broad River that where three outfitters operate now. In the 1800s, the Broad River was used for moving commerce or using goods downstream to markets. Today, there is no inland commerce on any of our inland rivers, none. But there is commerce in the form of recreational boating. And so y'all have the opportunity in this bill to clarify that public easement, not take anybody's property, but clarify that public easement to support that commerce that is taking place on all our inland rivers. And most of these rivers where this is taking place could arguably be said to be non-navigable. So that would be I would urge y'all to support the state's economy, the state's outdoor recreation and tourism economy. This will help support that. I'd be happy to answer any questions y'all might have.
I don't see any questions. Thank you, Mr. Cook. Next up is Eric Rogers.
Good morning, everybody. Appreciate the opportunity to talk a little bit. I am the chair of Georgia's chapter of the Native Fish Coalition. So our mission is to protect, preserve, and restore native fish habitat in Georgia. And so some of y'all may know this. I think Mr. Burns sounds like a fisherman like me, and that's really my driving force for conservation and why I'm here today, and also along with Georgia Rivers. I'm a board member for Georgia Rivers. Don't know if y'all know or not, but we have a couple of really economically valuable fish in the state of Georgia. So we've got the Southern Appalachian brook trout. It's the southernmost range of that fish in North America. And so that habitat is decreasing rapidly. So that's something that we work on. Also, the state riverine sport fish, the shoal bass, which I hope all of you are familiar with. I think that was a bill just in the last couple of years. Several species of native black bass in Georgia that people come in, and you may not know this, from all over the world to fish for, because you can only catch these fish in Georgia. So the Chattahoochee and Flint River basins, it's the only place in the world where shoal bass are native. So you've got people coming in literally from Europe, from South Africa. We've got, the arguably the most successful airline in the world. We've got the busiest airport in the world. These people come in, they spend a lot of money. They go, they're hiring guides, of which we have hundreds of guides in the state of Georgia, river guides. I'm not necessarily here to talk about fish, but I had moved to Georgia in June of 2000. One thing that became very clear to me, not being a native, but have been here more than half of my life now, is that Georgia's natural resources are really tremendous. And I think, I don't know if all of y'all have lived here your whole life, but I worked in the Orvis store. It's the third largest store in Orvis and Buckhead, and we had people like Eric Clapton come in. I actually talked to Jimmy Buffett one morning, and people would always come in and say, "You guys have fish in Georgia?" So I think there's maybe a lack of outside perspective of how people see Georgia, but when you're here, we have these tremendous natural resources. And what I've also seen is that people in the state of Georgia don't necessarily take care of these resources to the level that we should, right? That we should value these things. So I think the opportunity here for all of us in this room, and really all the state residents of Georgia, is we have an opportunity to lead in Georgia. Some things that maybe some people don't even know, and I didn't know. I'm a marketing communications professional. Georgia's the 10th biggest state, and correct me if I'm wrong on any of this, in our country, right? We have 10.6 million people per the last census. Atlanta is the 6th biggest metro area in the United States, so we have a ton of economic power here. We're a diverse state, and we've got these tremendous natural resources, right? So what are the opportunities here? Mr. Hughes, I think, talked about tourism and economic development. Rena had mentioned people being afraid to come to Georgia because they've got people yelling at them. People have been shot on the Flint River and shot at. And I know probably some of you guys are familiar with the whole Yellow Jacket Shoals situation on the Flint. But the opportunity here for everyone on this board is to open up economic development, help local small businesses, which I hope everybody in this room supports that cause, right? And be a leader in and I think what you'll find, and I know that the gentleman that got up and left the room, Mr. Walker, and then Mr. Ginn seem to be opposed to this. But what I think they would find is the more people that you introduce Georgia's natural resources to, the more those people become stewards of the resource. The more that opens up the opportunity for them to want to protect the resource, to clean up the resource, to take care of it, and then also potentially get involved in that resource and become part of the economic success of that. So that's what I would just say, that Georgia has an opportunity to lead here, and I think it's a missed opportunity if we all just go by 1849 case law and let that guide the future of our state.
All right, thank you, sir. Jake, you're up next. And then Adam, you'll be the last person testify today.
Thank you, Mr. Chairman, members of the committee. I appreciate your time. I will be brief. Thank you, Chairman Still, for the dialogue and the discussion. I'm with the Georgia Agribusiness Council. We represent farmers, landowners, and agribusinesses across the state. It is our belief that private property rights are the fundamental principle to this state and our industry. We participated heavily in the discussion a couple of years ago with the study committee, as well as House Bill 1172 that looked at the definition of navigable waterways, and we believe that it struck a fair balance for both landowners and public use. With that being said, one specific issue that we could see, we represent the Georgia Cattlemen's Association, and a lot of times there will be fencing across these streams. There will be cattle in the streams. And that could obviously cause conflict or inability to pass these waterways, regardless of the private property discussion. We're opposed to anything that will broaden the definition of navigable waterways, and we believe that in this broad interpretation of that, if you essentially just make non-navigable waterways navigable, then there is no need for navigable definition, so we're opposed to broadening that definition. Again, thank you to the chairman and thank you to the committee for hearing our concerns, and I'll answer any questions if you have any.
Chairman Burns.
Thank you, Mr. Chairman, and thank you for the input. I do have that concern. I share that concern. And I think the committee has to acknowledge the fact that some landowners may have the right to fence the stream.
Yes, sir.
In order to maintain their herd's integrity. So as we work through this, I want to make sure that that's not ignored. And it's a challenging point.
Yes,
Thank
sir.
you.
Thank you, Chairman.
All right. No other questions, Jake, for you. Adam Bellflower's up next. Georgia Farm Bureau.
Thank you, Chairman. Adam Bellflower with Georgia Farm Bureau. Good to be with y'all this morning, and had the opportunity to just briefly talk with the bill author about this legislation and look forward to further the conversation with him on this topic. This is an issue that is very important to our organization. We obviously represent farmers all across the state, but I want to speak to this more just not from the agriculture perspective, but from the landowner perspective and the value of private property rights and what this bill does. I do just want to publicly say, we object to the interpretation the previous gentleman had of the common law understanding from which our code originated. As it surrounds this issue. He brought up the Young v. Harrison 1849 case, and Chief Justice Lumpkin, in that opinion, he recognized three types of waterways in Georgia. One, arms of the sea, which were tidal waters where the water ebbs and flows, is the way he defines it. And then two other kinds which were intercoastal waters and the rivers that we're talking about today, one of those which supported passage and the other which a landowner had exclusive rights to. And he recognized that of those other two types of waters, the right of passage only was given to one of those two. That in common law, a right of passage was not extended to non-navigable waters. You see that idea directly reflected in our code when the statute was originated to reflect this common law understanding that we had. We now have in code tidal waters, which are our coastal waters, which we have a whole other way that we deal with them, and then we have navigable and non-navigable waters. There is a test. And what Chief Justice Lumpkin mentioned in his opinion was there should be a test to distinguish passage. And the test that we have is in 44.8.5, which is the test of navigability, which was mentioned earlier, which has to do with the waterway being able to support commerce and trade. And it does clarify that the mere rafting of timber or navigation of small boats does not justify navigability. There's a clear in Georgia code as we interpreted the law and the common law and the precedent that has been set by the Supreme Court is that a owner of non-navigable water has a set of rights and he has exclusive rights. One of those rights being access and passage. We see this bill 511 as a direct infringement on the private property rights of non-navigable landowners. The legislation that we have discussed in prior years dealt with the rights of the public to public access on navigable waters. We supported House Bill 1172, where it specifically clarified the right of passage on navigable waterways, but we do believe that non-navigable waterways have always held in Georgia, and this isn't law that's been around for decades. This is centuries old law, and this is law that really hasn't been touched in Georgia for centuries. And this understanding of navigability and non-navigability, we believe if you add passage, you are taking away a right from a landowner. And that is a taking that is being performed without compensation under this bill, and that gives us grave concern. Again, I look forward to continuing the conversation with the bill author on this legislation and talking with him, but just wanted to get up and point out a few of our concerns, and I'm happy to answer any questions.
Yeah, I've got a question for you. So,
yes, sir.
If I'm able to distinguish between the difference of what you're contending versus Mr. Pendergrass, you are essentially contending there's not two types of non-navigable waters.
No, sir. There's
Okay.
one type of non-navigable.
Okay.
There are three types of waters in the state. There's two types of freshwater rivers, and there's navigable and non-navigable. And I believe the code supports that.
You would agree that's the code now? Do you think that, is it your understanding that ever in common law or previous Georgia law that there were two types of non-navigable waters?
I do not, and I think the Supreme Court has stood with that opinion as well.
Okay. Is it your contention that that's essentially the core of this
Debate?
disagreement? Yeah.
Yes, sir. And I think to one of the comments you made earlier, Chairman, we were talking about the boundary lines on these rivers. Non-navigable, if you look at a land survey on a non-navigable waterway, the property owner owns to the center thread of that non-navigable water. And then, so if they own, that's where the whole idea, if you own both sides of the waterway, you can prohibit access because your land goes to the center thread of that non-navigable water. And this is laid out in code too, referencing back 44.8.5. If a waterway is navigable, the landowner only owns to the low water mark. They don't own the center thread of that riverway. And so that is where that right of passage exists. So I think that's a good point to clarify. A landowner, when their land is being surveyed, when you buy property, if you were to buy property, say, on the Altamaha River, we use that because that's pretty undisputed that the Altamaha is a navigable waterway. If you look at if you own land on the Altamaha, your land line, your property line goes to the low water mark. It does not extend to the center thread of that waterway as if you own land on a non-navigable, say, a creek. So that's one of the distinguishing factors of those two properties as well.
Is your contention that in Georgia law, since there is only one type of non-navigable water, if you were to allow passage, you would essentially run into a conflict with what Chairman Burns is speaking of, and what Jake spoke of, which is essentially the inability for your clients, for the farmers to essentially put fencing over?
Well, I
Not
think
navigable.
I think that is one implication. I think there's multiple. I mean, I think one is just you're taking away a owner's right in the same way that a landowner has the rights to the minerals on the property. In a way, you're taking away. I mean, access is a right. I think I would point back to this bill to line 18 and 19. What's not underlined, what's in existing law. If the owner of a non-navigable stream is entitled to the same exclusive possession of the stream as he has of any other part of his land. I mean, I think that's important to think about what that existing law says there. In the same way that a non-navigable stream is given exclusive rights, the landowner has exclusive rights over that non-navigable stream. Those exclusive rights and possession are just the same as any other part of his land. I
Great.
think the code's pretty clear.
Thank
the
you.
existing code.
Thank you, Mr. Bellflower. Justin, I'm going to ask you to get with Ledge Council and ask them to write an opinion for the committee as to how Georgia law currently is situated, whether it is what Mr. Pendergrass stated, that there's two types of non-navigable streams, or whether there's one type. And I don't know where he went. There you are. Why don't you come back up for a second? We're all friends in the room here. Thank you,
Yes, sir.
Adam.
Would you like me to stay up or sit down?
Why don't you stay? You know
Yes,
what? Why don't you, Craig, why don't you grab a seat right here at W2? I'm going to do this the same way those that were on the committee when we did truck weights. We had respectful, open dialogue between two people that had two varying opinions. I want to make sure that we're clarifying your position correctly.
Yes, sir.
Is your position that currently in Georgia law there are two types of non-navigable waterways?
Under Georgia law, under the definition, yes. Answer yes, to be
Okay.
simple.
Okay. So when we ask Legislative Council to go through this process, or our research department, they will find what you're stating. Obviously, Adam is saying that he believes that there's one. Help me understand why you think that he's wrong.
Okay, let me get a little bit real estate law wonky.
Sure.
And Georgia legal history wonky, but it's important, and Legislative Council will want to take this into account. As one runs back to the origin of chain of title of a property, that's a very important thing that title examiners have to do. And all private property in the state chain of title originated by the 1830s, after the Cherokee Land Lottery Acts of 1830. As the state developed, private property ownership came from the coast up into North Georgia. But so when each of those properties originated their chain of title by 1830s, the common law was in effect, and the common law placed under the, as confirmed by Young v. Harrison, a common law easement of passage. So if the legislature's intent, and it's not clear that it was the legislature's intent at all, in 1863 was to get rid of that common law easement, that would have been a violation of the gratuities clause of the Constitution that says the government can't give up its rights in a gratuitous manner. So the public's rights. So that is where, among other things, Legislative Council should be looking. They should also be looking at the Capital City gravel and sand case. It's the Chattahoochee case in 1910 that confirmed, yes, after the 1863 Act, there's still these two types of non-navigable streams.
So you think that he's wrong not because his plain reading of the current law is wrong. You think that he's wrong because the General Assembly passed a bill, or at least as the current application of the law is, would violate the gratuities clause tracing back through title code to the 1800s.
Yes, in part. Also, the 1863 code does not disavow the existence of public easement rights. You know, general real property law says landowners are entitled to exclusive possession, but we all know that that exclusive possession is subject to limits. That's a nice term. Among other things, zoning laws. Among other things, FAA, the overflow rights. So it's, in theory, ownership of land is to the heavens and to the center of the earth, but those are subject to limitations.
I just want to get clarity and try to give me clarity,
Yeah.
not law school thesis. Do you agree that the plain reading of current Georgia law has one type of non-navigable stream?
No.
Okay, so that's what we need clarity on.
Chairman,
Anything
you
you'd
mind
like
if
to-
I-
Yeah, I'd love for you to respond.
So I would agree with the gentleman's interpretation that a common law right of passage exists in common law. I don't have my computer in front of me. I can't read it. The direct quote from Young v. Harrison. I do agree. There is a very explicit, and I'm happy to share this with you, right of passage, but it is only extended to one type of waterway. It does not extend to non-navigable waters. It only extends to navigable waters. And I think, so I do agree with that, but I think that common right of passage, and by extending the common right of passage to non-navigable waters, is where the constitutional taking occurs.
And you're getting to what Pro Tem Walker was saying, which is essentially that is the distinction. He
Yes.
believes that the distinction between navigable and non-navigable simply is the right of passage.
The right of passage.
All right, I'll
And
give
and
you-
I think that is, and I think the code, again, to the gentleman's point, that a landowner has rights. I think the common law and in the opinion from the case that we're talking about, in the opinion, it mentions that on the two types of waterways, inland waterways, the navigable and non-navigable, exclusive rights exist on the non-navigable, and the landowner possesses all rights, but a common right of passage exists on non-navigable. So, I think the distinction is there. I think that it just does not extend that right of passage onto non-navigable waterways.
Great. I think we're good with you. I'm going to
Yes,
ask
sir.
you one question.
May I speak just briefly?
Let me ask you my question real
Okay.
quick, and then you can. I'm happy to let you do
Okay,
it.
sorry.
Walk me through the fence scenario.
That's exactly what I was
Okay.
going to do. So, sometimes we have to get practical as we understand rivers and flows and properties. And if somebody was to string a barbed wire across a river, if it's a river big enough to support passage, that wire is going to get blown out by the first big rain when limbs and trees and all that come down. So the sort of things we're talking about where, okay, I want to, fence off for legitimate purposes, the upper line of this little stream where my cattle like to come down and drink, that shouldn't really be a problem. But if you're going to try to say, well, if you're going to try to, for just the purpose of, stopping the public from coming down, put something up, well, it's going to get blown out with the first big rain. Think about that way. Because, again, we're talking about little things versus medium things, and and again, if the law was that only boats loaded with freight that you then define to be, big barges, was the basis for passage, there wouldn't be a single river in Georgia other than the Altamaha or the Chattahoochee down near Lake Seminole that would meet that.
So
or
you're
the
filibustering.
Savannah.
Let me try to reel you in a little bit. When can a farmer put up a fence?
If he owns both sides of that stream, and
What if it's, as you classified, your second category, which is non-navigable, where there's bed ownership and there's private property to the bed of the river, but it's capable of boat passage? Can the farmer put up a fence?
yeah. He could put up, actually, there's types of fences he could put up that would accommodate both, that would keep his cattle in and allow a canoe to pass through. You know, the floating
Can he
kind of
put up,
gates.
can he put up a fence for the purpose of keeping his cattle in that would not allow boats to float through
That's a
under the
good,
law?
I would generally say not, if that he should be accommodating to public passage rights by making it a type of fence that allows a boat to go under it. And again, you can have these things that.
Pretty sure if a boat can go under it, a cow can go under it.
Depends on, well,
So you understand the tension that's here. We're going to let our aspiring lawyer, who has his bar exam next week, by the way, so good luck. We're going to let him get with the other lawyers in the building to help us navigate this. Thank you guys for being here. I do want to recognize Senator Hatchett is in the room. You have an interest in this? Would you like to address anything to the committee? This is the first time I've seen you in the Transportation Committee, so welcome.
It is, and this
So
is
something must have piqued your interest.
a very important issue to my district and my constituents. I'm staunchly opposed to this. I'm staunchly opposed to the interpretation that's been given. I think the interpretation of a 1859 case law is being stretched to the point that it is appeasing boaters. When that case was decided, it was solely focused on commerce. It did not grant a common law easement in any way, shape, or form. If anything, it was a servitude for passage in commerce, which are two different things. As long as I'm in the state legislature, I'm going to be against this. And I want to go on the record saying that for my constituents, because this is a very deeply personal issue up in my neck of the woods. There are trout streams now that have been highly invested in, that used to be small creeks where you have a hard time even finding a crawdad, that now have trophy trout. And they're in no way should the general public be allowed to kayak or canoe on private property in Northeast Georgia. And I just want to go on the record saying that. So thank you, Mr. Chairman.
Thank you, yeah. Thank you for being here. Thank you for sharing. Any other comments from the committee? So yeah, I'm going to give Chairman Still an opportunity to close out. Before he does, I just want to say to Senator Dickerson, this is not the normal Transportation Committee meeting. This is like, if you liked this, you want to be on the Judiciary Committee. If you didn't like this, you want to steer clear of the Judiciary Committee. Thank you to all of those that came to testify. I do want to give Senator Still on 4 the opportunity to wrap up here.
I just want to say thank you to the committee. Thank you for the opportunity, Mr. Chairman, for hearing this. This has been a lot more time invested in it than I thought we would, so this has been great. For those of you in the audience, for and against, thank you for your input. Thank you for coming. Thank you for continuing the conversation. I think it's really important that we keep talking about this and make sure that we take everyone's rights and concerns very seriously as we continue. Thank you.
Thank you, Chairman Still. Thank you all for being here, and this meeting is adjourned.